Good afternoon, everybody. I'm Peter Spain. I'm a director in the commercial department at Werksmans, and I also have the honor of being chairperson of LEX Africa, which is co-hosting this seminar this afternoon on insolvency and business restructuring in Africa, which is, of course, a very important topic. And we're delighted to have LEX Africa colleagues from Kenya, Mauritius, Mozambique, Ghana, and Botswana, as well as Eric Levenstein, of course, my colleague in South Africa. And this shows the strength of LEX Africa. We are actually 30 countries with over 600 lawyers, and we turn 30 years old next year. So we've got a 30-year-old track record. We are the largest African alliance of law firms, and we are a one-stop shop, effectively, for legal services throughout the continent in all the major jurisdictions. I know that Eric will introduce the panel in a bit more detail, but I would just like to welcome you on behalf of LEX Africa. And I think without further ado, I think I'm going to hand over to Eric. Thank you.
Thanks, Peter. We thought it would be useful to get together this afternoon to look at various jurisdictions in Africa. The purpose of today is, in fact, the official launch of our Guide to Insolvency and Business Restructuring in Africa, which is available outside. In fact, this was published the first time in 2015. And what we've done over the years, we've updated it with the assistance of our colleagues, and some of them I will introduce you to them a bit later. This is the 5th edition of the Insolvency and Business Restructuring Guide for Africa. And it really is a pleasure to be here and to discuss aspects of insolvency, restructuring, business rescue administration in various countries around Africa. This publication has contributions from 23 different jurisdictions, and we've in fact had now an increase of 5 jurisdictions, as Peter said, taking out LEX Africa to 30 member countries around the continent. And the aim of the publication is to get people to understand how restructuring and insolvency processes work in the various countries. It's certainly not an easy task to get contributions in as much detail as we have over the years, but we are very proud to say that we achieved that. I certainly like to thank not just the individuals that I'm going to introduce you to now, but of course all of our colleagues at LEX Africa that have contributed to this publication. I think what's important about it, whether your client has subsidiaries in African jurisdictions or your bank loaning monies into an African jurisdiction, it's fine going in. The question is, how do you get out? And it's all about extracting value through a legal system. Now, the World Bank rates various countries on their regimes doing business, ease of doing business. One of the big tick boxes is, what does the insolvency regime look like in a particular country? What does the security legislation look like? Do we have a workable business rescue or restructuring or administration regime that makes sense and that works? What do the courts look like? Do our judges in various countries assist lawyers and clients in extracting value out of those jurisdictions? So that's what we're going to debate today. I'm going to introduce you to our member firms. Firstly, on my left is Sipho Siga from Armstrong Attorneys in Botswana. And then I've got Seth Sante from Bechi, Chowetsa and Nkoma from Ghana. Welcome, Seth. And from Kenya, we have Esther Kinyega from Captain and Stratton. And we have Deb Araya from Araya Chambers, Mauritius. I was going to get them to bring flags, but they didn't bring them. And we've got behind us on screen, very pleased to welcome all the way from Mozambique, Toma Ferreira from CJ Associates. So let's kick off and let's start debating some of the issues. I'd like to just pose this question to the panel, and that is just generally what's happening in your various jurisdictions. You know, how busy is the restructuring and insolvency world? What does the economy look like? Are we going to get busier in 2023? Are we going to see much of the same since the closure of the pandemic? So let me start with Sipho in Botswana.
Yeah. Now, from a Botswana perspective, the economy is on the road to recovery after the COVID pandemic. We are seeing a lot of economic activity going back to the pre-COVID days. From an insolvency perspective, obviously for the smaller companies that couldn't survive COVID, we are seeing a whole lot of insolvency and companies either passing resolutions to put themselves in liquidation or being put under creditor-driven liquidation. But for the major companies, significantly, there hasn't been any of the major companies that has gone into liquidation as a result of COVID. Currently in Botswana, there are three main big liquidations that are going on. Two in the financial services industry, which were as a result of fraud, and then one which happened pre-COVID, but which is ongoing for one of the biggest mines. You probably know it, PCL. So there are a lot of small insolvency matters ongoing, and a few of the big companies, like the two I spoke about in the financial services industry and one in the mining industry.
So the banks getting a little bit more aggressive with their lending methodologies for foreclosing on credit out there, or was it much of the same?
Because of COVID, I think the banks gave creditors a little bit more leeway to see what would happen, whether they would bounce back and be able to pay. But banks' primary remedy is mainly usually to enforce their security rather than to pull the plug on companies. So what we're seeing is that banks are now starting to enforce and trying to recover on their security rather than placing companies under liquidation.
So I was remiss in not introducing my colleague, who's on the far end of the room. Her name is Lauren Beck, I'm sure. Dev, just what's going on in Mauritius?
Well, good afternoon first. I guess many people are really here because I know about Mauritius. As an athlete of COVID, we have also had our thoughts, meaning that we have not been doing well since COVID, and with that kind of pressure and trade aggression, it was about to get worse. But looking at the recovery in the tourism industry, Mauritius is picking up, and Mauritius is doing quite well. We are on the road for recovery, which is quite steady and stable at this time being. We are classified as certain country by the World Bank on the ease of doing business in the world. So among 190 countries. As regards litigation, I would say we have very good law to prevent people, especially opportunities, to take the opportunity of public to just wind up company, those companies through employees. So we had very, very good legislation which prevented actually companies from filing litigation or impact, and we had laws which protected their employees as well. And the good thing with Mauritius for the time is why it is picking up, especially in the financial services sector, is because we are no longer on the blacklist for financial and fraud, the European Union. So that is giving us edge to actually recover and build up our financial services sector, which is very, very important for Mauritius. And as I said earlier, tourism is playing a very significant factor. We can even notice an appreciation in our local economy and also in our currency, which is rupees. So we are matching euro, pound sterling, US. This is very something that even is people. All the costs we have.
Dev, I mean, you had a very big filing 2 years ago in Mauritius.
Yes.
Now it's back up and running ready for the December holiday season.
Yes, that was Air Mauritius, the national airline. I think it was one of the public company in which they went on administration. So the administration is over now. The company is back on the rail after the whole that lasted for about 18 months. So the airline is finally back and is capable from here. I mean, it's very difficult to finally see the difference from Juba, from Mauritius to company. So the airline is in work.
Still, tell us a little bit about Ghana. Have you experienced much the same as what you've been hearing about now?
Well, I don't think that's any American. Ghana is not doing so great on the economic front, I'm sure most people would have had. The country is not reaching legally to have World Bank an IMF deal bridged. The economy is in significant trouble with having serious challenges, forex reserves and currency inflation is rising. But I think so. Everybody's just waiting to see that economic deal can be reached by December, hopefully. And that could send a good signal to the markets and stabilize things. I think the general economic front, as I said, it's looking quite weak. But there is, we haven't seen it caused insolvencies or any business rescue transactions in the market. I think people are still getting funding. Companies are still surviving. I'm not quite sure for how long. We don't have a long tradition of companies who are in trouble going into liquidation. People just sort of limp on trying to find ways to survive. And so it's sort of a wait and see. We have new legislation in the market that has introduced administrative and rescue provisions. It hasn't got much test, hasn't been implemented significantly. We've seen only one or two transactions that it has been used for. And so I think the crunch will be next year if we haven't got an IMF deal by December to see how the market's going to look. So it's a delicate time.
Steve, you mentioned to me this morning that Ghana is swinging towards more of a rescue culture. What does that mean? Is it more informal rescues, or when you see workouts happening more in distressed companies?
So historically, we didn't have a rescue regime in Ghana. So historically, Ghana, like most common law countries, would have, if a company needed to rescue, would be done a scheme of arrangement or a scheme of compromise for creditors. Very difficult to achieve because you need 75% amount of creditors to do it, or creditors may decide not to participate in the transaction. But I think in 2020 we got a new rescue provision. The new legislation for insolvency, we introduced business rescue provisions. It hasn't been implemented in Sydney. I think I mentioned one of the transactions. I'm aware in much detail about one transaction which hasn't gone very well because the administrator hasn't sued by the shareholders, saying that he has failed to rescue the company, which is quite ridiculous. But so the law is just started. I think that's in most countries. It will take time for the law to bed in and the market to understand how the law plays and practitioners to know how to use it. It's still a developing scenario.
Is that what's happening in Kenya and similar to other jurisdictions or different?
In Kenya, we've just had a very successful election. There was a fight for the Supreme Court, but the loser accepted the results. We have a very tough business environment at the moment. We're experiencing drought. In Kenya, inflation is almost reaching 10%. The shilling has depreciated a lot. So we're really seeing a lot of administrations going on, especially by the banks. So this is set to continue.
Are the banks sitting back, waiting to see what's happening, or are they calling in COVID loans for companies that own?
So now they're calling them in, but during COVID, they gave distressed companies some leeway, so they cut themselves slack, but now they're calling in.
Okay. Tilma, in Mozambique, what's your sense right across the border from South Africa?
Hi. Good afternoon, everyone. Look, the Mozambican economy has been struggling during the past years. That's due to the lack of confidence and international finance resulting from the hidden debt scandal that you might be aware. Then we had COVID, which also impacted the economy. And we do have the conflict in the north of the country, which suspended the main gas project in Mozambique with a huge impact on the economy. So these are reasons, or should be reasons, to see many of rescue files and insolvency files. However, the legislation is quite recent. Both companies and creditors are not very familiar with it, and therefore we've seen very few cases of liquidation. We haven't seen any business rescue, but we've been seeing some liquidation process promoted by banks as creditors, and we've been involved in some. We think that it might increase because the economy, although now the international financing is resuming, but there's a huge inflation due to as the result of Ukraine war, and we foresee that not only that, but the fact that companies are starting to get familiarized with the legislation and legal regime. We foresee that more and more cases of business rescue and liquidation will happen.
There's no track record that people aren't buying into the business rescue legislation, or is it the banks just not confident about the way it works?
Well, look, there's no track on that, and banks use the liquidation as a last resort. So they try to manage as much as they can directly with their clients. And whenever they can't, as last resort, they request the insolvency of companies in order to save as much as they can their credit.
What is important, I'm going to ask you to please ask questions on this next question, which is very important. That is the security regime that might exist on security registrations in each one of these countries, right?
Yeah, if I can just say, what we're going to do is we're going to ask certain questions to certain of the panelists. So not each of them will necessarily give us information from their jurisdiction, but if there's something that's pressing that you want to ask that we haven't covered, feel free to address it as and when. So I think, just looking at the security and understanding that we have quite a few representatives from the banks and the financial institutions here, I think it will be important to understand the security that's available in all jurisdictions, and in particular, whether or not the court processes are required in order to give effect to that security, to enforce it, and what kind of registries exist to determine what security has been taken by creditors and to what extent it has in the rest. So I think, Esther, you want to perhaps tell us about Kenya, what's available, and how does it work?
So in Kenya, we have debentures, which can provide for fixed and floating charges. We also take charges and mortgages, share pledge agreements, and other limits.
And tell me, is the court required in all instances to enforce the security? Or are there options for creditors to recover on the security outside?
Yes, so for share pledge agreements, you don't have to involve the court. And also for movable assets which are registered in the National Registry, those do not have to involve the court. But for administration and the debentures, those you must.
And you mentioned the registry. Is that only in relation to movables?
Yes. So we're finding that people are registering both immovables and movables, even though we have a land registry which is specifically for immovables.
Okay. And I think, does that sound familiar?
It does. I mean, Ghana is a common law country, so as most people who are familiar with common law jurisdictions, there's a very flexible collateral and security system. So every type of security that is available under English law, in other English law jurisdictions will be available in Ghana. Mortgages, share charge, security assignments, pledges. So the whole gamut is available. And the law allows for creativity. Apart from being able to set up security, in recent times, reforms of the law has allowed an easy, relatively easy enforcement of security. So you can't enforce all types of security without having to go to court. In terms of security that you need to take physical possession, you can go to court. If there is a resistance to you entering premises to take possession of assets or even a building. So the law has, in recent times, been significantly modernized to create a framework for lenders to be able to easily enforce security. We sometimes still end up in court because some borrowers resist. They have lawyers who file also spurious processes to delay time, but still we get things done. So I think the process is improving and is being modernized.
How does that process change? So if you're not using the court, once you're using a court system, how do you actually go about enforcement?
Thank you. So we have a system called the collateral registry system, which came into force in 2007. Complete online registration system, so you can create a security and register it within 5 minutes. And if there is a default,
the law requires you to give a 30-day notice of default to the borrower. If you give the notice and the borrower doesn't perform, you serve a notice of your intention to enforce, you get a consent from the registrar to enforce, and then you can go and take the security. If it's a share charge, you simply file your blank share transfer form with the company for them to enter your name in the register. You can also take the asset, and you can sell the asset by private auction, a private sale, or public auction, whichever you choose. And it's supposed to be a very easy process. It doesn't always go this easy. In some instances, borrowers will resist, and therefore then you have to go to court to get the assistance of the court to have the enforcement process complete. But it's been significant.
When you speak about the security regime in Ghana sounds very elegant and smooth, and as you said, it doesn't always go so smooth. What is your recommendation to your clients with taking up security? What is the first point forward, and what do you look at next?
So first point of call depends on the nature of the asset. What is land? What is movable property? Do your due diligence well, make sure the asset it's clear title, there are no encumbrances on the asset. And then get your documentation properly done. After that, contract security. The law allows you to stamp duty in our jurisdiction. Most of you know stamp duty. Stamp duty is a documentary tax on security. Under our law, you pay 0.5% tax on each security instrument. So you can be 0.5% of the secured liability. They can be quite expensive. But it's quite expensive to the borrower. Normally it's priced into the loan, so borrowers are completely aware of us. And so you have all that done, and then you file your security, make sure it's within the proper trial. I think when everything is done smoothly, and I think you will, and when you are enforcing, make sure that all the processes are done properly, notices are sent correctly. Then you are likely to be able to surmount any challenges from the borrower. As I've said, I mean, you can't have instances where it is done smoothly. I give the example earlier when we were speaking about we being able to enforce security, significant security against a fertilizer warehouse operator who will decline. Within about 3 weeks to a month, we managed to take possession of the assets and auction, which was quite, even in those times, they went to court. They tried to prevent us, and we went to court and police to assist us to get the assets. So the system can go quite smooth in some ways.
And I would imagine that when you're engaging the registrar, amongst the register of the security, that they could also object to the enforcement for technical reasons.
They could. So the registrar could object to security, for instance, the security has not been fully perfected. Perfected means that you've paid the stamp duty. Or the borrower has an objection. The borrower says, well, I don't owe money, or that the money that you say I owe is not up to what's say. And those instances can delay, but they can be resolved.
Okay, and simple. Does Botswana boast such an impressive public collateral registry?
Not yet. Our security regime is separated into basically security over movable and security over immovable. Security over immovable can only be taken by way of a mortgage bond, which you registered. So that's very clear. And you can only enforce recovery or foreclosure under that mortgage bond through a judicial process. With movable property, it's not so straightforward. There are various types of security you can get. But the best form of security is a form of security known as a deed of hypothecation, which is created by a separate statute, standalone statute, called the Hypothecation Act. In terms of the Hypothecation Act, you can take security over movables, either generally or specifically, and that gives you a first ranking charge over that security. However, there's a catch. For you to be able to take a deed of hypothecation, you have to be designated by the Ministry of Finance as an authorized creditor, which means you apply, it's usually a letter, you apply to be designated, and then you are considered as an authorized creditor. Almost all the banks are authorized creditors. Those lenders who come into the country for the first time would invariably apply. It's a process that can take anything from 6 weeks to 3 months, depending on the official dealing of the bank. So that's the deed of hypothecation, and it gives you a first ranking charge over the asset hypothecation. There is also the possibility of entering into a notarial bond, which is a common law notarial bond. But that doesn't give you a statutory pledge over the asset, which basically means you only have a secured claim over those assets once you've been able to go to court and secure possession of those assets. So it's not a very common form of security for mover. Then the other forms of security are your usual common law pledge. That's not registrable at the deeds registry. It's a pledge, and usually it applies for shares, where because a pledge under the common law is completed by delivery of the pledged asset, and the practice is usually to take the share transfer forms and the share certificates to perfect the pledge. And then the other form of security, also not currently registrable, is the cession to secure a debt. And that's also not registrable, but it's recognized as a form of security. And it's usually used to secure incorporeal structures, book debts or other non-tangible. However, there's a new act called the Movable Property Security Registration Act, which was passed earlier this year, but it is not yet in operation because they're still drafting the regulation, and it's going to replace the Hypothecation Act and widen the ambit of registration to cover pledges and all sorts of security over movable, and then establish a collateral securities register, which I understand is going to be an extension of the functions of the current deeds registry. In terms of that draft act as well, there's a provision there that enforcement shall be through the judicial process. So we're not going to work towards making it easier to enforce. We are maintaining enforcement through actually going to court and getting enforced.
And there, you nodding. I think your system is based on French origin. So what are the nuances in your system that are different from what we've heard here and which are typically used?
Yeah, well, Mauritius being a hybrid system in law, where our law is based mainly on the civil law, which is the French law, Mauritius being an expert in the funds, and then on the common law, Mauritius also being an expert in law. So we have a very unique system of law for the security, and we have a canopy of security. If we start with privileges, we have two types of privileges, which you make all references to. So you have normal privilege, and then you have special privilege. We have lien, we have personal guarantee, we have corporate guarantee, which is very important for banks making loan to companies in Mauritius. Then we have a pledge, which is a conventional pledge that is quite difficult for enforcement because you have to go to court to enforce those pledge. The problem is that pledge in the majority of Mauritius is there's no power of sale if you are in the pledge of sales. The impact is the sale. Eventually you have a blank sales from control and appropriate sales to your cycle in time. The problem is you have to use the court, get an expert assess value of sales, then apply to the report of order to be able to dispose of those sales. The other difficulty with that, conventional pledge is you don't have the right of subrogation. That will be difficult with that. So what happened is like with those difficulties, we have approached the government to actually bring a new system of pledge under our French Code de Commerce, or especially to sue international financial institutions. Because under the normal pledge, international bank cannot pay security over sales in Mauritius or any group. So under the Code de Commerce, which is the best security in my opinion, financial institutions, say bank, teams, want to lend money to a global business in Mauritius, which call also business or company. The Mauritian parent subsidiary and the South African parent company will actually deem the pledge with sale in the Mauritian company under the Code de Commerce. The advantage of the Code de Commerce is you have a direct power of sale. So you have automatic power of seizure by way of this blank sale transfer form, which is signed and mandated. So the lenders have the power to actually sign that transfer form at the time of default, and then acquire those shares and decide whether to sell those shares without being this is direct part of sale, which can exercise within 7 days of this. However, the pledge agreement and the collective commerce will have to be registered as well as all other pledge which we take for the security of the be it our privilege, especially. They have to be registered in the Mauritian law, because when there's a civil law, you have to get a register with date. So only a registration which is, under the registration for duty act will allow you to get that registered with date, which in French we call that share, and that registered with date will also determine your priority in case of any winding up or enforcement or whatever. With the collective commerce, the pledge is a foreign institution, like, say, an example, I don't know if there's any of you that investment bank, or you actually lend to a company in South Africa, a subsidiary merge, and the parent company want to actually give a pledge of the shares in Mauritius, and the collective commerce will be very easy for the bank in South Africa to take possession of the shares without being. It's a very flexible tool and very important for international financial institutions. Previously, they could not do that. Enactments are very limited for anyone for domestic banks registered in the Banking Act to be able to take steps now. It is open and give a better tool for financial institutions internationally to take those activities. Apart from that pledge, we also have fixed and floating charge, which is very good security for lenders. The problem with fixed and floating charge is with fixed charge, you can't take security for the futures as opposed to the interest. So you have to take a fixed charge over fixed asset, and then you have to take a floating charge, and because that gets into be complicated, because for the float charge aspect, if you want to enforce, you have to crystallize the floating charge into a fixed charge, and then actually enforce it. But having said that, even for fixed and floating charge, you don't have to go to court to enforce. So all those security I have listed, you don't have to go to court to enforce, except for those conventional banking challenges.
Thanks, Bill. Okay, and Thomas, last but not least, I think in your jurisdiction, if I'm not mistaken, the mortgage and the pledge are the most commonly used for financial institutions. Is that correct?
Yes, that is correct. We do have two categories of securities: real securities, which are mortgage and pledge, and which they respect a specific asset covering the liability. And then you have personal securities such as the suretyship, promissory notes, and others. Banks, as you said, banks and other creditors tend to adopt and to create the most robust one, which are mortgage and pledge. Mortgage relates with immovable assets, and pledge relates with the movable assets, rights. Sorry?
Yeah, the registry.
Yes. The mortgage are registered before the real estate registrar office. All the mortgage. The pledge and any other kind of security is registered before a central securities office, which is quite recent, and it became functional this year, but securities are already being registered. And both the real estate security, the real estate register office and the central securities office, they are of public consultation, so anyone can consult the securities being registered. Another aspect is that in order to enforce a pledge, you can enforce without the intervention of court, as long as you have agreed that with the debtor under the pledge agreement. A mortgage can only be enforced judicially with the court intervention. So, and these are the main aspects regarding the securities. I don't know if you have any other question.
Yeah, I think Look, I think just from a South African perspective, we don't have a movable assets registry, so we're lagging behind the rest of the jurisdictions, us in Botswana. But yeah, I mean, if there are any questions at this point that you want to raise, feel free to do so. Otherwise, we'll move on. Yes, John.
Yeah, just a comment more so than a question. Thank you to the panel for sharing the information, and thanks to LEX Africa for this comprehensive booklet. But I may be stating the obvious, but just to have a bit of participation from this side, to say that it's clear that local knowledge is very useful, but very necessary, clearly, because in different geographies, there are different securities, and different securities are more robust than in other geographies. And even where we're talking about the same security, or ostensibly the same security, the processes and procedures are different from country to country. And hence, it's probably obvious to all of us that it really is necessary to have the benefit of local knowledge. Because if you don't have it, I think you're going to come short.
But John, I often speak to the London law firms, and they love this booklet because they can obviously contact any one of our colleagues to get local knowledge. They can't advise clients as to how to register security in Botswana or whatever it might be. So it's essential. And not only on the registration side, but on the enforcement side. To even consider writing letters off the back of security registered in Mozambique, for example, be highly dangerous now. So that's the whole purpose, actually, of LEX Africa. Any other questions on security? Yes.
How long does it take to be
In particular jurisdiction?
in Ghana?
In Ghana.
Well, thank you. As I said, you don't need to go to court in Ghana. But if you have to go to court, as I've said, it really depends on how terribly frustrating the lawyer on the other side was. And we have seen processes where lawyers file serious processes, abuse in the court process. And you need a strong judge under those circumstances to catch the student and say, we're admitting what you want, let's go to enforcement. Let's go to that. So in some instances, if you have a good judge, then the peace process can run. And remember, that doesn't only stop to the judge. You have a right to appeal, and so these things can roll. But I think in most things, realize that if the court system works well, I have seen them done 3 months, 6 months, but I've seen them that it can be quite frustrating for some lenders. So sometimes the lender looks at the situation and decides that if the borrower is going to resident, they'll just sort of engage and see and test the situation and decide that whether they go to court, original type agreement, borrower and restructured facility, or some instances like that. But the system itself, as built, is supposed to be efficient.
Regarding pledge in Mauritius, that's a conventional pledge I referred to earlier. It is taken from the Article 2174 of the First League of Mauritius. In the enforcement of such a pledge in Mauritius, there's a case which went to the Privy Council, which is the highest court of Mauritius. It took 7 years to enforce the pledge just to get the court actually the power of claim. Because the pledge was wrongly taken. This is why I subscribe to what John said. We have to have knowledge of international and local law to be able to get the security, which is very good for the back of the lender to fill out.
No, in Botswana, the position is almost similar to what Esther alluded to. Generally, for banks, they will be in a position to get judgment either because the debtor doesn't oppose, and there's a large percentage of debtors who don't oppose simply because they don't have a defense, or if they do oppose, there's a process called summary judgment, where you can actually get judgment fairly quickly. And usually the court looks whether the debtor has any defense which is capable of being referred to a full-blown hearing. And most of the time, the defenses are very, very poor because, the documentation is there. The debtor signed for it. They took the money and they didn't return. So you usually get your judgment between 6 weeks and 3 months in ordinary debt matters.
It's a question over there.
Yeah, I want to ask a question to the Kenyan lady. I know there is a lot of common receiverships happening in Kenya as a way of enforcement. Can you just give us a bit of more context around that, as opposed to business liquidation or dealing to those?
So before 2015, we had a lot of receiverships. Then we passed the Insolvency Act. So thereafter, all administrations have to go through court. So we've not seen a lot of business rescue in Kenya because debtors are always running to court, to stop the process, and creditors are not agreeing in terms of, when they hold different securities. The only successful one is Kenya Airways, similar to Airways, where all the creditors got together and agreed, to rescue the airline. But most of the time, it's just administration, and the court has to supervise that situation. So we no longer have receivership, only for securities that were there prior to 2015. Any new securities after 2015, you have to go to court for administration. But there are those securities, for instance, if you have a mortgage or a charge of a property, you don't need to go to court. You just advertise it. You can sell it by private treaty or by public auction.
Okay, let's move on. I want to deal with first the informal processes as we know it in South Africa, and Lauren's going to talk about the formal processes, what's available in each jurisdiction. In South Africa, we have a tendency to engage with creditors and with the debtor company. It's a way of a consortium of creditors negotiating what we call an informal workout or an informal restructuring. Of course, the danger of doing that, particularly when you've got aggressive creditors, that might apply for winding up. There's no moratorium or a stay on claims, and it becomes very difficult to do a restructuring when there's no moratorium. But a lot of the banks, and a lot of you sitting here today will say, let's rather do an informal restructuring if we can, rather than go through the formal processes. I'm interested to know, let's start with Telmo, whether or not in Mozambique this is something which is an option, and is it seen quite often?
Yes, it is an option, and we've seen it quite often. Actually, our experience tells us that, and we work a lot with banks, and all the banks, before applying for a liquidation or an insolvency, they always try as much as they can to agree with debtors the restructuring of the debts. That we see that a lot, and in many cases they are successful, and they are able to agree with debtors ways facilitating the compliance by the debtors, avoiding going to an insolvency process. Yes.
Tell me, what about aggressive creditors? How would you stop them from enforcing claims against the company?
Sorry, can you come again on that one?
How would you deal with aggressive creditors who want to enforce their claims against the company if you're doing it informally?
Well, look, if they want to do it informally, that depends on an agreement between creditor and debtor. If they do not agree, the only way the creditor has is to go through a formal process. Or before, if they have a real security, they can enforce the real security even without applying for a business rescue or a liquidation of the company.
Yeah. Well, I think informal processes are not very popular in our jurisdiction. I think creditors there's no incentive to engage in an informal arrangement with the creditor when there is among creditors when there is a default, unless there is an intercreditor arrangement system which allows for a standstill so that there's an orderly process. You will see creditors without that sort of arrangement, stealing a march on the others and going to court trying to enforce its spirit. There is no incentive for them to play. So what we see is that unless there is a security sharing arrangement and intercreditor arrangement which contractual allows for a standstill or some moratorium, this is just going to fall apart for 2 days of speaking to each other. Before you know it, one creditor is going to instruct most people. And so it doesn't work. Most people will tend to go through enforcement or the formal process.
In Botswana? No, in Botswana, I've seen it working where banks are involved. banks will generally cooperate with each other. In fact, last year or thereabouts, there was a very big sort of like informal settlement by the banks in respect of one of our large retail supermarket companies, where all the major banks in Botswana came together. First, they negotiated a standstill to say that they wouldn't institute proceedings without the consent of the others. And then they negotiated a syndicated financing to restructure the debts of the company. That informal arrangement, however, was limited only to the banks and excluded other creditors, such as trade creditors, who were then settled through the group finance. So it is there, the option is there, and I've seen it happening in real time. Yeah.
Does that happen in India?
Not very frequently, unless it's an interlenders agreement. The absence of such an agreement won't work. And it's be amongst the banks.
Now, Mauritius, we have 2 ways of doing that. And we did work well during COVID, where there have been the free process of negotiation and forward. However, our system provides for a standstill procedure, which happens from the insolvency associations. So during that standstill situation, we will have 3 or 4 elements, usually around 8 principles, but 3 or 4 elements are very essential. We need to have a cooperation between the creditors. We need to have an agreement between the creditors, and we need to have also an agreement that the creditors will, any of one of the creditors will not enforce its security during this. That is very important. And to answer your question, actually what happened during those 3 stages, we want to get intelligent check and we do enforce it.
So for directors of South African companies, they get nervous when the aggressive creditors enforced. That's when there's a fine for business rescue, which brings about automatic moratoriums and plans. But of course, our experience, Lauren will agree, I think, bigger the debt, more banks are involved, more chance of an informal workout, which is too much to lose. And if you've got one aggressive creditor knocking on the door, that creditor will probably be settled by, maybe even by the banks. Do you agree on that?
Yeah. And I think it seems that the common thread here among all the jurisdictions is that you need agreement. You understand stuff and the South African agreement. I think that's how it is in South Africa. If I could just
on that agreement, it has to be pre-existing, or it can be something that gets entered into when you find that there's different lenders, but you want to form a lender, and you can create the agreement at that point, not that it pre-exists.
So in my experience in South Africa, agreements can be reached with banks which aren't necessarily in a consortium, but they form a lender group for the purpose of reaching agreements on a standstill. So I think Seth was alluding to the fact that in intercreditor agreements there might be options for standstills already at the outset when the lenders advance money into a country. But that's not to say that you can't necessarily agree at a later stage.
But I think we need to be realistic that when the borrower is in trouble, it's much more difficult to do. You put the banks in the room. This guy is looking at this bank, his security. It's not so. Mine's, I think I better going to settle to where it was. And that kind of thinking makes it more difficult, in my view, to reach an agreement because, and banks have different economics. Some banks have pressure on NPLs, the central bank is on their back. They feel much more reluctant to wait and reach an agreement, which can take a lot. So I think, if you are, if there are multiple banks, I think, if it's possible to put in a creditor, before things go bad, that's
maybe this time, you should be opportunity in emotions. In emotion of the context is the creditor, whether they say the creditor has met or not, they are bound with the creditor into an agreement because of the security they have taken, the rank first rank, second rank, third rank, fourth rank. So assume that the bank or the lender having the fourth rank goes up to enforce its security. So they will have to have the consent for the first one first. If you don't get the consent for the first one, then the second one is zero. The fourth rank cannot enforce it. So the block is why it is important to have an agreement among the creditors separate from an intercreditor.
Okay, and I think if just going through the formal processes, so everyone's touched on already in the discussions what the different processes are. I think it's fair to say that each jurisdiction has a voluntary and a compulsory liquidation process, and it seems like most are straddling the rescue process. So if you could just confirm for us what is the traditional liquidation and insolvency process, and then where are you with your rescue or administration processes, and in what instance will a company choose such a process?
Maybe Simo could start because you can tell us about judicial management. We jettisoned as we some time ago. That's interesting to speak to Simo this morning because judicial management is still very much part of Botswana law.
Yeah. What we have is basically voluntary and involuntary liquidation. Voluntary liquidation is where the company puts itself in liquidation. And usually there, when it does that, the company needs to basically give security for the payment of debts. So there it's usually when you want to close down the company. The other form of liquidation is where you petition the court for liquidation. And the process is fairly simple. You petition the court and usually you will get a provisional order. That's the practice, which you get in a few days, a week or so, because most courts recognize that liquidation is inherently urgent, and they'll hear you and appoint a provisional liquidator. And then there's a return date after publication, which is usually in about 6 weeks' time, where any person may come in and either oppose confirmation of the order or support the confirmation of. This can either be extended by the court, or if the court feels that the company can be turned around, there's the option of putting the company under judicial management. And judicial management is usually granted where the court believes that it's not just equitable to put the company under liquidation, and that judicial management would actually allow the company to trade itself out of its insolvent circumstances. It's fairly flexible. There's no prescribed time period for the company to be under judicial management. It's as long as it takes, but creditors can go back to court and say, this must now be put under liquidation or taken out of liquidation. So judicial management is not really common in Botswana because it doesn't impose an automatic moratorium like business rescue. A court would have to give an order granting a moratorium.
To what extent do you think Botswana is going to follow suit with business rescue legislation?
Yes, I'm currently involved in a matter right now where one of our arguments is that the company is insolvent, but that because the whole world is moving towards judicial management, that's where our court should be looking. And we're waiting to see what the judgment is going to say. But I think it's likely that when they do review the insolvency laws, they will move towards rescue provisions which are comprehensive, rather than now where if you demonstrate that the company is unable to pay its debts, then you liquidate.
Is there scope in your jurisdiction for the creditors to request that a moratorium be imposed in terms of the court law?
In the case that I'm talking about, we actually proposed that they got support from other creditors to say instead of liquidating, perhaps the moratorium be imposed. And it remains to be seen if the court will agree with us. Because one of the other things in Botswana is that there aren't a lot of decided cases regarding these sort of issues. Because most of the time when petitions are made for liquidation, they are not opposed, simply because the company has no resources to oppose at that time, and it's obvious that it's in liquidation and it can't be saved. So we rely a lot on precedents from other jurisdictions such as South Africa. The difference being that in South Africa now, there's the business rescue regime, which we don't.
Okay, and
in immigration law, we have administration, and after the administration, the company, if it is unable to pay debt, some stage before administration, they have to pass a resolution So I said, appoint a litigator or an administrator. In most cases where the company is there and has a matter for appeal as well, especially when you have various creditors, so the company will pass a resolution to appoint an administrator. The company will do an administration. And when that resolution is passed, it is like a sort of moratorium and stay of any other action with the other creditor name. So it's more like a sort of dealing tactic to prevent the secured creditor to enforce its security over that company. So just like the case of the Mauritius, they quickly pass a board resolution, approve an administrator, and then they file the paper with the register of companies. So the company is in that. If the company is not in administration, you can't do anything until the administration is over. Now, when administration is over, the purpose of administration is to get the company back on going as to whether you can be legally concerned or not. So if it is, like in the case of Mauritius, then there's no proposal for if administration fails, then the administrator will have proposed that the company be a liquidation. So that will be in both company arrangement, which is very useful in the law, and that in part that what is in the company liquidation. The liquidation in Mauritius is voluntary as well, or it is creditors liquidation. So once the company is liquidated, is the signature of the debt.
You mentioned administration, and you said that the aim is for the company to continue to trade as going concern.
Yes.
Are there instances in which, as in our law, in the business rescue, that you might rather achieve a better dividend for creditors than in a liquidation, or is that not?
From my experience, in the case of Mauritius, we're very involved in that. For a cooperation between creditors and the debtors, where like gets the company, right? The company was in which the government was state. So the company could not go into it.
And do you have any schemes of arrangement?
We do have scheme of arrangement
from the administration process.
Well, you get in the administration itself, you can have a scheme of arrangement between creditors. But if you do have that, you have to be approved. And the deed of company arrangements, we go DOCA, right? And that's exactly what I want to say.
Yeah.
So whatever is approved in the DOCA, what the binds all the.
And does that scheme of arrangement effectively compromise claims?
That's right.
So without the scheme of arrangement within the administration, there's no real compromise of claims. And Esther, anything different in Kenya?
No, actually, largely the same. After the Insolvency Act came in, we've seen a lot of banks facing companies in administration. Unfortunately, very few business rescues, successful business they normally end up in.
Is it also called business rescue?
No, we don't call it that. In fact, I realize in South Africa you call it business rescue, but we don't use that term in Kenya. We just say administration. But the idea is for the company to continue running as a going.
Okay. And Salma?
Well, in Mozambique, we do have two main formal processes. The first one being the business rescue of the company, which is applied for by the debtor itself, as long as complying with certain requirements, and which results on the agreement with the creditors and the business rescue plan, which can establish several administration process and other aspects. Then we have the liquidation of the company, which can be requested by the debtor itself, its shareholders, or any creditor. While in the business rescue, the company continues to be managed by the board of directors, although supervised by the liquidation administrator and the creditors committee. on the liquidation of the company, the company is managed by the administrator, liquidator of the company. Then we also have what I call a semi-formal procedure, which is a non-judicial business rescue, which can be agreed between the debtor and creditors. It's not run by courts, although needs to be deposited in court. And the agreements between the debtor and creditors on this extrajudicial business rescue are regulated by the Act of Mediation and Conciliation, the Mozambican Act on Mediation and Conciliation.
A process, but it has its own rules under mediation and arbitration.
Yes.
And said,
we do have quite similar system to what they've described in Mauritius, with some differences. I mean, in Ghana, a company can go into administration based on two tests: the cash flow insolvency or net worth insolvency, and it has a negative net worth. So the directors can put a company into administration if they think that there's a potential to be rescued. But to avoid abuse, the structure is such that if you go into administration, basically within 28 days, there should be clarity as to whether you can get refinancing, because the whole purpose of administration is that you can get new financial shareholders, existing creditors or new creditors. So if within 28 days you haven't managed to do that, the creditors can go to court and ask for administration to be terminated, appoint a new administrator, or put the company into liquidation. So it's a very short window for you to save the company. So I think the purpose of the real intention behind the drafting of the law is to ensure that the directors don't use administration to frustrate creditors and then wait for a long time, because during administration is moratorium on enforcement of security. Legal action intended against the company is stayed unless you get leave from the court. So the law requires a very, very strict process. Within 7 days of administration, you must call a creditor meeting. When you call a creditor meeting, the creditors can remove the administrator if they don't think he's competent. Within 28 days after that meeting, you have to call what is called a watershed meeting, where you must bring a restructuring proposal showing that you can resuscitate the company. If you can't, then it has to come to an end. The creditors can go to court and bring the administration process to an end and have a liquidation process, crucial liquidation process start. But I mean, as I said, I mean, this is all beautiful written in law. We're just waiting to see how it will be implemented. As I said, the one case that I'm aware of has ended up in court, very frustrating for the administrator and the creditors. But I think the way the law is drafted, if it works, it will be beautiful, because then you really can't use that process to frustrate the creditors.
Everything has potential.
Absolutely.
And it doesn't. And Aaron, I think this.
Yeah, on Sister 16, I mean, I'm just giving it timeline.
Sorry, say that again.
And then similar timelines, okay?
No, unlike Ghana, we don't have that 1 month period. It can take between 3 months to 1 year. What we've experienced is debtors, justice treating so where there's no agreement, it can take forever. So we're seeing administration taking longer than 1 year, 3 months.
Just quickly, Dave, how long would an administration take?
Yes, well, there again, you have a treaty in the law. The problem is there's a provision to extend 28 days. So the administrator, normally they are very clever. Before the expiry of the 28 days, they will write to the court to get that extended. In the case of Werksmans, the administration went over more than 18 months. And because it was a government company or a shareholder of that company, so the court is very prone to extend, as opposed to a private company where the government will not say, the court say, no, I'm not going to.
I think the good thing in Ghana, the court can extend, but it can't extend beyond 45 days. And you must show cause why it should be extended. The creditors can come to court and oppose the extension.
But the administrator will always say, well, it is a complex administration.
in particular, completed a business rescue in 45 days.
What's the timeline for just generally for your liquidations? 18 months, 2 years?
Oh, no, 2 years, 2 years, 3 years liquidation takes a very long. Getting the order, the provisional order, you will get it in a week. The final order probably between 3 and 6 months. The whole process winding up the company. Now you're talking again. Judicial management, it's usually a matter of months when a company is in judicial management. But in my experience, creditors then get very impatient and invariably go to court and say, put this company in liquidation. There's no home for this company paying itself out of its position. So that never takes more than a year.
Well, a liquidation in Mozambique takes around, considering the case which we know, takes around 2 to 3 years. Regarding business rescue, there's a limit time frame of 2 years.
Richard, here, I love this watershed meeting. Maybe we should turn our 151 meetings into watershed meetings. I like the drama of the name. Yes. Just thinking about the effect on, obviously, shareholders, I would assume is similar to South Africa. Shareholders are out of the money, generally speaking, unless there's something left in the pot. What's the effect of your system on employees? Let's just take them, for example, from administration versus liquidations.
Yeah. In case of administration, the employee stays. Okay. However, the administrator has the power to report to serve notice on the employee within 21 days of the appointment for the administrator to terminate the employment, as opposed to liquidation where once a company is.
Is that the same in Kenya, more or less?
For administration, if the company is going on as a going concern, the same terms continue for them. For liquidation, obviously, the employment comes to an end and they have priority in terms of payment of their debts.
So be prepared times.
Yeah, that same priority applies.
So that is the
same amount of 50,000.
Limited to 15,000. And said in Ghana,
very similar to what my colleagues have described, just that in Ghana, in a liquidation, the employee's entitlement to priority is only up to 4 months wages. The rest of their claims will have to be
with us almost similar. They're protected up to 3 months, not 4. And in judicial management, the judicial manager has to continue the contract unless the infringement following the normal process of the case.
Does that happen often in infringements in the jail?
In judicial management, not often. But in liquidation, usually liquidators, the first thing they do is they definitely go and pay off the 3 months and then they become concurrent creditors for the balance of their case. But in judicial management, because usually when a company is in judicial management, there's an intention for it to continue on the same base. They want to keep the employees to show that they get paid amount. Yeah, but invariably it ends up having to be turned into liquidation. And I'm not aware of any judicial management that has been successful.
Well, look, employees, they rank as, they are the first ranked as creditors. And that relates with the insolvency liquidation of the company. Both liquidation and business rescue can result on dismissal of employees. They can be part of, under business rescue, they can be part of the creditors committee. Depending on the business rescue plan, they might be able to appoint a director to the company. So yeah, there are some measures to protect them, and the moratorium in order to pay their credits regarding the past 3 months prior to the declaration of liquidation cannot exceed 30 days for an amount equivalent to the 5 minimum wage. But that's about it. Yeah.
Vision around paying within a year. Is there any requirement that the employees must be paid in relation to remuneration or work-related incentives that needs to be paid within a year?
Yes. You cannot establish a period more than a year to pay remunerations which they are entitled prior to the declaration, and rights that they have resulting from employment accidents.
Question? There was a question over there.
More responsibility of the directors depending on
That was going to be my next question. But let's clear that directors' claims and comes against directors trading, obviously running the company in just a situation where it can't pay its debts, kick the can down the road, all of these things. In South Africa, we haven't had a huge amount of litigation around that. We have had some case law. We can also declare directors to be delinquent, which is a very interesting term. Dev, in Mauritius?
In Mauritius, under the Companies Act, the directors have the duty to actually resolve that the company is unable to pay its debt. Therefore, either we will do it or not. That is a law. So it's a mandatory. So if the directors fail to do so and actually let's say the company on liquidation is found to be unable to pay its debt at that time, then the director becomes personally liable, right? And we had a case law, the case of general construction, where it was held that the director was personally liable at circumstances. But if I may add there, Eric, there is a development to happen in relation to director liability into the common law, especially those in Insolvency Act, mainly the UK, Mauritius will be included, I think Ghana, Kenya as well. There is a case law which did 5th of October 2022. Its name is BTI against Sekina, right? So in that case, it is laid down that the director owes a duty to the creditor first before to the company and to itself. So that's going to change the landscape in relation to directors' liability. So with that case, we'll see more directors. Those who are directors here making note. We see more directors going for personal liability.
That's an English case.
It is an English case.
You would be bound to.
Well, you will be bound because the British Council is our final court of appeal. And I think it will change the landscape in the common law jurisdiction as well.
Might even influence our case law so that as precedent.
Yeah, I actually think that the principle, I mean, if you look at Ghanaian jurisprudence as a system for quite a while, I mean, the view has always been that when the company is a going concern, the directors owe their fiduciary duty to the company and ultimately commercial to shareholders. But when liquidation is imminent, when insolvency is imminent, they first have to have the interest of the creditors at heart, and the common law is always upheld. So I think the case cited by them is actually consistent with the system principle. The view under Ghanaian law would be that if the director, whilst knowing that it comes imminently will be unable to pay, continue to incur, then that director will be personally liable. The creditors have sued, and that has not been statutorily mandated because under our new Insolvency Act, there's actually criminals. So a director who engages in fraudulent trading is where you trade knowing that the company will be unable to pay its debts, is liable personally. So the veil is lifted, the director is personally liable for all the liabilities of the company incurred during that period. Beyond the civil liability, the director is a criminal liable, and it can lead to imprisonment of 2 years. So it's actually very significant for directors who knowingly engage. And I think the test is very difficult for the director to say, I didn't know when I was misled. I just didn't have trust. It's almost, I think it's almost that when you are accused, the burden shifts on you to prove that you actually did enjoy it.
And said that there have been cases where directors have been prosecuted.
We have cases pending in Ghanaian courts now. We went through banking sector cleanup in 2018, and the Bank of Ghana has brought litigation, but not by creditors, but the regulator has brought litigation against directors who mismanage those banks. In some cases, through what we call liquidity support from the regulator, which is the lender of last support, when they knew that those banks were insolvent. And they have sued them. So we'll see how those cases.
But so on the simple.
Yes. We have comprehensive provisions regarding negligent trading and personal liability of directors in case of insolvency. We don't yet have case law. There is a pending case in court now, but involving one of the liquidation matters I spoke about areas. We are suing the directors for directors' trade, and that will be the first such case to be decided in Botswana. But the provisions are there. They're very comprehensive. They include criminal liability, civil liability, And similar to what Seth had said, if a director incurs obligations on behalf of a company when he has no reasonable belief that the obligation will be fulfilled, then they become personally liable. There's also a lot of mechanism in our insolvency law to hold directors accountable. For instance, we have a provision that when a company is liquidated, each director of the company, who was the director at the time that it went into liquidation, is obliged to attend the first and second creditors meeting and all other meetings until he is excused by the master. It's an automatic obligation. You don't even have to subpoena, have to be there. And at that meeting, there is also provision for any creditor, the liquidator or the master, to actually question them on the affairs of the company. So that provision has been involved in the most recent liquidations that have taken place, the big ones in Botswana, and with great success, because that questioning revealed a whole lot of things that gave rise to the chain that I was talking about.
Yeah, in South Africa, we have to convene a forward civil inquiry and some whole procedure, whereas it seems that the system is quite user-friendly for asking the right questions of directors. Lauren?
Yeah, in addition to director liability, I think in your jurisdiction, you have your limited liability companies and your what we would say unlimited liability companies. And in that instance, what effect does the liquidation have on shareholders? Can shareholders be held personally liable to contribute to debts of companies in circumstances where the company has been placed in liquidation?
Look, we do have two kinds of shareholders. In most companies, shareholders have their liability limited to the share capital. In those cases, shareholders are not liable under a liquidation. Although they might be restricted from exonerating from company or transfer their shares during the liquidation process, they are not liable for the company's liabilities. We do have, under our legal regime, other kind of shareholders, which are those with unlimited liability. In those cases, in relation to those shareholders, whenever the company is declared insolvent, the shareholders are also declared insolvent, and they are liable towards the company's debt. But let me tell you that because of that, and because of the fact that their liability is unlimited, and nowadays, and I would say at least for the past 30 years, I've never seen a company being incorporated having shareholders with unlimited liability.
Director liability?
Okay, on director liability, they might be liable depending on their actions. That includes fraud to creditors, illicit disposition, dissipation or unjustified encumbrance of patrimonial assets, appropriation, lack of organization regarding bookkeeping, personal expenses, other unjustified decapitalization of the company, simulation of credits, omission of credits, all that might result on directors' liability. There's also a general principle under the commercial law which states that directors which they put the company in such a way which will not allow it to comply with creditors' rights, they become liable towards creditors too. So this is a general principle on commercial law, but then the insolvency law establishes specific cases under which they are directly liable and which might result on criminal sanctions too.
Is that do you actually find prosecutions of directors at all?
Yes, especially in respect of criminal liability. We had a supermarket called Uchumi Supermarkets, which was publicly traded. Some directors and some managers were actually criminally convicted. So our capital markets authority is quite strong, especially for publicly listed companies. So directors of those companies have to do that. In fact, recently, about a month ago, the Capital Markets Authority fined some directors for a certain bank which had funded.
Okay, so that's active litigation.
Yeah.
Okay, I think we get to a close. Just one or two last questions. I'm just interested to know who takes appointments in your various jurisdictions. In South Africa, of course, we have liquidators. We also have restructuring professionals or business rescue practitioners that would take appointments in a rescue situation. Where do your administrators come from? Your judicial managers? Are we looking at lawyers? Are we looking at accountants? Do they all have to be licensed in your various jurisdictions? Let's start with Dev.
Yeah, for instance, in Mauritius, a liquidator administrator has to be licensed as an insolvency practitioner. That license will be given by the registered companies. And in most cases, I would say majority of the cases, the lawyer license to act as insolvency people. Then they can act as administrator or litigator or receiver.
And what professional qualification these individuals have?
The priority will be accountants and lawyers.
You trust lawyers with financial
aspects?
Is that?
Mostly accountants, they have to be registered as insolvency practitioners. Yeah, we don't have lawyers being.
I'm the same as what they're saying. Mostly lawyers and accountants licensed by the registrar by the insolvency service.
Then among the big four, we have one of the company being registered as insolvency practitioners.
No, with us, it's almost exclusively accountants, and normally from the accounting firm, the big four accounting firm, and other accountants. And there's no qualifying for the process is such that the provisional order appointing a liquidator is usually made by the court. And as part of the petition to liquidate, you motivate the credentials of the person of the court. And then when it comes to the confirmation of the appointment, that's done by the creditor, but still subject to confirmation by the master. And it's usually based also on the credentials of the person, their experience, and their ability to actually act in the role.
And there are a lot of these individuals that are up for it.
Unfortunately, there aren't a lot of. It's usually the same people that, and when they're conflicted, there's really a problem getting people willing to act as liquidators and things like that.
Well, in Mozambique, insolvency administrators can be lawyers, economists, managers of companies, and accountancy, as long as they have the right experience to do so. However, there's a regulation under which insolvency administrators must be certified and registered before a specific entity, which belongs to the Ministry of Justice. And in order to do so, they have to pass an exam, which is promoted by that institute.
Questions from you for any of our speakers, delegates, one. Before we wrap up, I just want to say this, that, we're listening to everybody today, and I'm sure Lauren agrees with me. I mean, the principles are very, very similar. And when you look at the principles set by Insol, for example, creditors, stakeholders, whether it's shareholders or employees, are all dealt with. Maybe nuances might be slightly different, but at the end of the day, the objective is to maximize value for creditors and to try and get the restructuring through as quickly as possible. So let me start with Dev. Dev, where do you see us going in 2023? Are we going to get busier? Are we going to get quieter? What is your setup?
I wouldn't be a optimistic person. So that seems to be pessimist. That same applies to Mauritius as well. We are looking ahead for very optimistic year in 2023. And also that the tourist industry is picking up. And as I said earlier on, the Mauritian currency can match with Euro, USD, GDP as well. So we don't see downside coming, except if we over again. Then we do. Having said that, we are on the right way. Our financial services sector is doing very well, and our economy is on the verge of coming. So we are very hopeful for 2023. In 2024, we had election. So I'm pretty sure the government have 2 years to make everything sweet so that we think there is more. And that's basically, I think, Mauritius.
Doma, your sense of next year?
I think that more and more the legal regime will be applicable by companies, creditors and debtors. They become more familiarized with the legal regime. They better understand the benefits of using this legal regime. And there are some economic challenges that probably will put some stress on companies and will take us to this kind of process. Yes. Like inflation, Ukraine war, interest rates increasing. So there are some economic trouble coming there. So, yeah.
In Kenya, politically, we are stable. So that's very good for business. However, the business environment is very tough. And unfortunately, I see more administrations.
From our perspective, I think we are on a very slow recovery from COVID. But the current government seems to be very aggressive and seems to have good intentions in attracting a lot of foreign investment. They're going out there and encouraging people to come. And people do have an interest in investing in Botswana. The only problem is that, the pace of making reforms to make business easier to deal with is quite slow. And this frustrates a lot of foreign businesses. But things can only improve going forward. We also have an election in 2024. It's going to be quite an interesting election. The only problem is that when you're now facing elections, governments tend to then focus on the wrong things. And it may then, starting from 2023, you may now see the focus shifting from attracting foreign investment to a lot of domestic policy matters, which aren't really good for business, but are intended to be for purposes of winning election. But we're hopeful.
Seth, when I look at markets at the moment, thank you. I look at markets at the moment, I always say more money in the system, probably more money available for distressed M&A, for acquiring companies that are in distress. What's your sense of 2023 in Ghana?
Well, I think when I started, I said we are in economic dire straits. So it's rough watching. We can't go down any further. So we can only look forward to going up. Since the COVID in 2023, we get an IMF deal. Same as what Sipo said, in Ghana, we have an election coming up in 2024. Historically, there has been a year when governments tend to be fiscally indisciplined. But when you don't have money, you can't be fiscally disciplined now. So I think we hope that government will be disciplined and the economy will have a turnaround. I don't see the market for rescues, distress transactions changing much. I see companies still be able to sort of tap out the situation and assist. So I think the key is on the market that we get some sustainability move ahead to build.
Great. Well, I think we're going to leave it there. I want to thank our panelists. I want to thank Lauren. Obviously, I'm thanking her for difficult questions to the panel. I want to thank Anushka at the back end who put this all together. And of course, our panelists who have contributed to our guide and have done a lot of hard work to prepare the call today. So we thank you to all.
Werksmans attorneys, keep us close.